One of the biggest complaints I hear from heirs and beneficiaries is they don't know what's going on in the probate process. They say that the administrator or the executor doesn't keep them informed. Here is something you should know that is designed to keep you informed. Legal notices. Hello again, this is Certified Probate Real Estate Specialist Daryl Williams with Win-Win Realtors here in Southern California. If you are new here and you like our content, be sure to like, share, and subscribe. Let's get started. Part of a public probate process is publishing and delivering notices to all interested parties so they may have their right to object, or in the case of creditors, so they may have their right to file a claim against the estate. These notices also serve the purpose of protecting the executor or the administrator from future lawsuits. Let's begin by identifying the document that initiates the entire probate process here in the state of California. That is Judicial Form DE 111, Petition for Probate of the Estate of fill in the blank. Once this document has been filed with the probate court, the probate process begins. A few weeks after the petition for probate has been filed with the court, one of the first notices must be filed, then sent or given to all interested parties. That is Judicial Form DE 121, Notice of Petition to Administer Estate of fill in the blank. The purpose of this notice is to put all interested parties, to make them all aware that a petition has been filed with the Superior Court to administer the estate of the person named. That way, no one should be able to say they didn't know what was going on in that particular case. This notice provides all interested parties with a hearing date that they have a right to attend and state their reservations about the petitioner or make their objections in general. Beneficiaries and heirs can expect to receive notice of hearings. Notice of hearings are required on all upcoming proceedings so that all interested parties have the right to participate, such as a notice to administer the estate and a hearing on a petition for final distribution of assets. All of these notices are required to keep beneficiaries, heirs, and other interested parties informed so they may exercise their right to object. If you are a creditor, you also have a right to receive a notice of hearing. The law requires the personal representative, that is the executor or administrator, to notify all known creditors of a probate proceeding. This triggers a 4-month period for which creditors must file their claim against the estate or forfeit their right to do so in general. And the last notice we're going to take a look at in this video is the Notice of Proposed Action. The attorneys refer to it as the NOPA. The NOPA is used on what's called full authority probate cases. Those are cases where the personal representative does not have to have the court confirm a lot of things that are happening during the probate process. What happens is, to give you an example, if a property, an estate property is placed on the market for sale and the personal representative receives an offer, the personal representative can accept that offer, send out a NOPA for consent from the heirs or beneficiaries, and sell that property without having to go to court and confirm that sale. However, if the heirs or beneficiaries object to that sale, a court confirmation hearing would be necessary. Question of the day: have you ever been an heir or a beneficiary of a probate estate here in California? If so, do you remember receiving the notice of petition to administer the estate of? Let us know in the comments below. Here in the state of California, it is the law to give proper notice to all interested parties so they may have the right to express their reservations and object in the estate. I'm Darrell Williams. This is Win-Win Realtors TV. If you know someone that's dealing with probate real estate here in Southern California, let them know about me. Share this video with them. This video has been for information purposes only. It is not legal advice. I am not an attorney. If you need legal advice, please contact an attorney. If you need information in relationship to real estate or estate real estate, property that's in a trust administration, probate administration, conservatorship administration, feel free to reach out to me.